Hi, I'm Attorney Paul Bernstein of the Bernstein Law Group, and in today's Estate Planning Questions Answered, we're going to answer the question, what are the 5 types of powers of attorney? To begin with, let's talk about what a power of attorney is. A power of attorney at its core is someone authorizing someone else to sign on their behalf. That could be for legal documents, financial documents, to assert rights they may have. So it's a very important document. Without a power of attorney, especially if someone were to become incapacitated for some period of time, we'd have to go to probate court to have a conservatorship put into place where the court would grant someone else the authority to sign on the incapacitated person's behalf. So power of attorney is giving someone else the right to sign for you. The legal right. Now, what are the 5 types? Well, first there's a general power of attorney and then a limited power of attorney, the first 2. General is at its core saying this person can assert all my legal rights and sign for me on all my financial and legal documents. Very broad authority to sign for someone else. A limited power of attorney is something smaller than a general. A classic example of a limited power of attorney is someone is selling a piece of property, but they're going to be out of town, at the time of the closing. So instead of delaying the closing, they give someone else the limited authority to sign all the real estate documents so that the closing can happen. So it's very limited, the authority under that power of attorney. In that example, it's just to sign any real estate documents. They couldn't take that limited power of attorney and go to the bank and start dealing with banking authority if the power isn't granted in that document. So that's the first 2. General, broad-based, limited, very specific, typically. Then we have a durable power of attorney. In the standard power of attorney that's not listed as durable, if the person that grants the authority to sign on their behalf becomes incapacitated, the powers in the power of attorney become null and void during periods of incapacity. A durable power of attorney, the third type, says you can sign on my behalf and that authority continues even if I become incapacitated. So we find in the estate planning context, often we are granting for our clients or having our clients sign durable powers of attorney, and they're frequently general durable powers of attorney, which are stating if I become incapacitated, or even if I become incapacitated, this person or these people have the authority to sign for me and assert my rights if I'm incapacitated. So no one has to go to probate court to get a conservatorship. Really important documents. So that's the durable power of attorney. Continues even if someone becomes incapacitated. And then the last 2 are either an immediate power of attorney or a springing power of attorney. Now the immediate power of attorney, let's get back to our estate planning context. That's saying I'm giving this person the general authority to sign on everything for me, even if I become incapacitated, and that is effective upon my signing this document. Now some people might have some concern giving someone that authority right away while they're fine. So that's where the 5th type, a springing power of attorney, comes into play. A springing power of attorney grants the authority only upon the person becoming incapacitated. So theoretically, a springing power of attorney makes an awful lot of sense. Giving someone else the authority to make all decisions for you, avoiding probate if you become incapacitated, but you don't want to give them the ability to do that until you're incapacitated. However, in real world practice, we find springing powers of attorney can cause some real problems. Banks are concerned just accepting powers of attorney to begin with. They're worried to allow someone else to sign for you. And they're worried that the person that's signing no longer has that authority. And if they give them the money that they're asking to withdraw under the power of attorney, you may sue them. They're concerned for you to make sure that that power of attorney is appropriate at that time. If we add on the wrinkle that you have to demonstrate that you're incapacitated too before the authority happens, that just makes it more difficult for the banks to determine, yes, this person has the authority because our bank customer is incapacitated. To demonstrate incapacity has to be really clearly stated in how that's determined in the power of attorney. But even under that circumstance, many financial institutions will reject springing powers of attorney. They're just too concerned about them. So for a vast majority of our clients, we do general, durable powers of attorney that are immediate. Does that mean it's appropriate for you? Not necessarily. These are important conversations to have with your estate planning attorney, but wanted to make sure you were well aware of the 5 types of powers of attorney and to start having you think about the importance of them. As I mentioned, in the estate planning context, without a power of attorney, we're off, a durable power of attorney, we're off to probate court when someone becomes incapacitated, hoping the probate court appoints someone that is appropriate, and hopefully they won't take too long to make that appointment, and hopefully it won't be too expensive, and hopefully not too many people will be rooting through that probate file to see what's happening there. For all those reasons, most people want to avoid probate so they don't have to rely on hope. I hope, speaking of hope, that this helped clarify some questions you might have had about powers of attorney. If you have any other estate or asset protection planning concerns, feel free to reach out to us. We'd love to help answer any questions you might have. Thank you.